Thank you, Russell, and as with other speakers, I'm very grateful to the AIC and the ACC for inviting me to speak today. It's a great privilege, particularly following to such distinguished speakers. One of the themes throughout this conference in relation to organised crime and cybercrime in particular, and we just heard from the Assistant Commissioner, is the importance of international cooperation. And the focus of my presentation today is on the legal frameworks that underpin that ability to effectively cooperate internationally in what is truly a global crime. And so what I'll be focusing on is really the nature of harmonisation of laws in the cybercrime environment, looking at the Budapest Convention in particular to illustrate what harmonisation means in this context, the challenges that it presents, and give some sense of what is an incredibly dynamic international environment at the moment in this area. I just want to begin. Some of you may have seen this image published in the press a couple of months ago. This was a hacker's attempt purportedly to provide a map of the internet, and what he did was that represents a botnet. Well, sorry, he utilised a botnet of over 400,000 unprotected computers to then conduct a distributed port scan, and what that purports to represent, that image there, is the over 400 million responses to that port scan mapped across the world. And you can see as it ebbs and flows in a mesmerising fashion over the 24-hour cycle as the IP addresses come online and go offline. And it's a striking image because it illustrates so perfectly how interconnected we are, but also how effortlessly transnational cybercrime is. Pretty much any country where there is an internet connection is vulnerable to cybercrime. And that may be deliberately chosen by offenders. They may deliberately choose to exploit the transnational nature of cybercrime. But one of the things I want to emphasise is that it can also be inadvertently transnational. A crime may be local, but because of our network communication technologies, the communications are routed through multiple jurisdictions. Data may be stored outside the jurisdiction. And so even a localised investigation can have transnational consequences. Now, although we live in a very connected world, it's not an evenly connected world, as this image from the 2013 UNODC cybercrime study illustrates. And for anyone who's interested in cybercrime, I highly recommend this study to you. It's an extraordinary insight into the current cybercrime environment. But what you see there, you see countries like our own, Canada, the United States, countries that we traditionally cooperate with, have very, very high levels of internet connectivity. But there are vast sections of the world that have far less connectivity, and you can see countries in black there with less than 10% connectivity. So what that illustrates to us immediately, when we're going to start talking about harmonisation, we are dealing with very diverse capabilities, and we're dealing with very diverse agendas in relation to technology generally. These investigations, this cooperation is challenging for countries such as our own, which have high levels of capacity. You can imagine the difficulties that many other countries face in just having the capacity, no matter how good their laws may be, the capacity to actually enforce. A striking example from me was a response from a small Pacific nation for which criminal copyright infringement was not a big issue online, but spam was. And the reason for that was they were not yet connected to a submarine optic cable. The bandwidths in that country were very, very low. And so there wasn't really the opportunity for a great deal of criminal copyright infringement, but spam was a real problem because they were back in the days when bandwidth was very low. That is the opposite of the situation. In a developed country, criminal copyright infringement for us is huge. Spam we treat as an administrative sanction. We don't really treat it as criminal. So we're dealing with very, very diverse interests. Now, the Assistant Commissioner has helpfully gone over some of the definitions of cybercrime, and I'll just skip over that quite briefly. The two categories that have already been discussed are well known. The first are what we would truly call hacking offences, the true cybercrimes, where it is the technology that is the target of the offending. And then there are many offences that are facilitated by the technology, such as fraud, child pornography, copyright infringement, etc. But something I want to focus on, which is very significant in relation to harmonisation, is that in the sense of digital evidence, potentially any crime is a cybercrime. The technology is so ubiquitous, there is so much communication that takes place using digital technology that whether it's drug offences, terrorism, homicide, whatever it may be, there is potentially the involvement of digital evidence. And so the capacity to deal and conduct effectively digital investigations and the presentation of that evidence is relevant to the investigation and prosecution of all types of crime, potentially. Now, something I wanted to talk about just briefly here is, of course, cybercrime is not a precisely defined crime type, and there is considerable overlap at both ends, both with traditional crime and with cybersecurity. I've already touched on the overlap with traditional crime, and I don't need to say much more about that, other than improving our capacity in relation to cybercrime and cooperation in that context has flow-on effects for crime more broadly. The cybersecurity issue is very topical. Because electronic information technology is so essential to the way we live, it's really regarded now as part of the critical infrastructure and something that needs to be protected as part of a national security agenda. But what we find here is an easy overlap that can happen between, for example, a denial of service attack which may be seen as a criminal law matter or may be seen as a national security matter involving securities agencies. New Zealand at the moment, to illustrate the controversy, has very controversial legislation going through at the moment. You may be aware that GCSB, the security agency in New Zealand, assisting in the investigation of Kim.com. Now, legislation is being put through New Zealand Parliament at the moment to clarify the role of the security agency in providing capacity to assist law enforcement with lawful execution of their powers. It's an intensely controversial issue because you get this very easy overlap between securities agencies and law enforcement. Many of the powers that we talk about in this context are also exercised by security agencies, and the need to carefully delineate the roles of those agencies because they can work closely together and often dealing with similar crime types. The danger when you have that conflation in the discussion of cybercrime and cybersecurity is it can stall law reform. It can be difficult at the domestic level, but when you start talking about international harmonisation and you're talking about security agencies, then it raises the controversy of those proposals even further. So it's very important to be clear on the distinction between cybercrime, law enforcement and cybersecurity. Now, this has already been touched on, so I will go through this briefly in terms of it's clear that cybercrime can be both serious and organised, whether that be online child exploitation, identity information, denial of service attacks. And as has been touched on in other sessions, what we find is this may be organised crime, but it may be of a type that is different to how we would see traditional organised crime. And as the White House strategy points out, on the other side of the coin, traditional organised crime organised crime groups, of course, use the technology to facilitate their business, and so capacity in this area is important in addressing organised crime. But again, we need to think about how we define organised crime in this context. So to take the major international instrument, the Palermo Convention, the Convention Against Transnational Organised Crime, if we just take two aspects, key aspects of the definition of organised transnational criminal groups, they may need modification, they may not apply to the online environment. This convention is highly significant in dealing with serious organised crime online, because it has provisions for mutual assistance, extradition and international cooperation, but crucially has so many member states as parties. When I last checked, it was about 177 member states were parties to this convention. It's extraordinary uptake and has enormous potential to provide that level of cooperation. But if we look at the organised crime group, as you can see there, a structured group of 3 or more existing for a period of time acting in concert, to commit serious crimes in order to obtain a financial or other material benefit. Just to take that last point, of course, there are organised crime groups that do act for a material or financial benefit, but there are organised criminal activities online that aren't for a financial benefit. They may be ideologically driven, for example. Similarly with transnational, one of the definitions of transnational is where the offence is committed in one state with substantial effects in another. What is a substantial effect today? If there are infected computers in your jurisdiction but the harm is not caused in that jurisdiction, is that a substantial effect to make it transnational? If data is passing through or is stored in a jurisdiction, is that a substantial effect? Why do we harmonise? Well, it's vital for 2 reasons. One is to eliminate safe havens. If laws are not in place and the person cannot be prosecuted in that jurisdiction, then they can effectively act with impunity, particularly because in the absence of dual criminality, even if extradition provisions are in place, it may not be possible to extradite in the absence of an offence in both jurisdictions. This famously occurred back in, I think, the early 2000s with the love bug virus, where the United States was pursuing the offender who was found to reside in the Philippines. There was no offence in the Philippines dealing with the virus at that stage, so could not be prosecuted in the Philippines, nor could he be extradited to the United States. But it also, crucially for the purposes of this discussion, facilitates international cooperation. The need to have this underpinning legal framework. There is an awful lot of international cooperation that goes on voluntarily between law enforcement agencies, but there are times when formal mechanisms are necessary in order to make formal requests. And without that level of without those legal frameworks underpinning international cooperation, it's much harder to conduct effective investigations. But when you're talking about harmonising a crime type that potentially operates around the world, so even if you look at the quintet, for example, so we're commonly operating with the United States, with Canada, the UK, New Zealand, so cognate common law jurisdictions, even we have our differences in how we approach these issues. When you're translating that to literally a whole world of countries potentially to cooperate with, we need to remember that harmonised does not mean identical. Countries bring their own perspectives, as they are entitled to. They bring their own national agendas to how to deal with these laws. So the laws do not have to be identical, they just have to work effectively. Harmonisation is very easy to say, and we tend to focus on substantive criminal offences. Have we criminalised hacking? Do we have child pornography laws in place? In a sense, that's the relatively easy part. The harder part is what follows. You can have a substantive offence, but if you don't have the investigative tools to investigate it properly, you're not going to prosecute it. If you do not have jurisdiction over that offence, you're not going to be able to effectively prosecute it. And increasingly, if you're unable to internationally cooperate, you're not going to be able to effectively prosecute. So harmonisation can be said very, very quickly, but it involves an extraordinary range of legal provisions. I mean, we were very fortunate at acceding to the Convention. Our laws were very much up to speed and largely required adjustment in terms of international cooperation, but we already had sophisticated substantive laws, procedural laws, and also jurisdiction. But for many countries, this is an enormous ask to put that many laws in place that are actually going to be effective. So let's look at the Convention on Cybercrime. The first and arguably still the most comprehensive international instrument, binding international instrument in this area. It's been around for a long time, open for signature in 2001, in force since 2004. I'll come into more detail later about parties, etc. But for purposes of being here today, we became a party to the Convention as a non-member state on the 1st of March this year. Now, I'm going to go through a bit of detail here, and I was trying to think of how to truncate this, but I will walk through this reasonably quickly. But there's a lot of information, but it's important to illustrate that point I made about when we talk about harmonisation, we say it very quickly. But when we talk about this convention being comprehensive, it really is very comprehensive, and bearing in mind what I said earlier about the challenges of putting these laws in place. So first of all, we start with substantive offences, and this is often where the focus begins and ends. So it's necessary to have hacking offences. The number of computer-related offences, which could be very, very broad, is actually very narrow under the Convention, and in my opinion is the most disappointing, the most limited aspect of the Convention. It deals only with fraud and forgery. Child pornography, on which there is almost international agreement in terms of condemnation, is included as the only content offence. But even there, we differ. The United States, for example, does not criminalise. Well, in fact, most of the world does not criminalise simulated images of child pornography. We, for example, do. Criminal copyright infringement is included, though countries are only expected to comply with their existing international obligations, but on an online environment. In 2006, showing that this is an ongoing process, the additional protocol in relation to hate speech was added. It's often said that there are a number of offences missing, and that's absolutely right. It doesn't deal with identity theft, which is, I think, a significant omission, reflecting the drafting at the time, which was the late 90s. Sexual grooming is not included. Spam, as I mentioned, for developing countries, this is often regarded as an issue they want to see criminalised. Many developed countries don't. Cyber terrorism. I don't know why people think that adding the prefix cyber is going to do anything to get international agreement on the meaning of terrorism and how it should be addressed. And certainly, digital technology can be used for terrorist purposes, but it is often stated as something that is missing from the Convention. The Convention is not perfect. It does not cover everything. But the fact that it doesn't include these offences does not mean that it is fatally flawed. It is simply saying these are issues on which there will be continuing international and regional discussion about tackling these offence types. And that may involve an additional protocol to the Convention, but it contains substantive offences on which agreement could be reached at the time. Spam and cyber terrorism in particular, I would suggest, are issues that would be unlikely to achieve international consensus of any meaningful type. But then we get to the procedural laws, is where it gets really difficult. And again, I'll go through this briefly, but there's often a misconception about the Convention. What it does require is a preservation regime. That is the ability to order, for example, an ISP to preserve digital evidence pending further request. It's still subject to further request. The point I want to emphasise here is it does not require a data retention regime. It is often spoken about as if it does. It doesn't. As you know, this has been very controversial in Australia. We don't have a data retention regime, but we are compliant with the Convention. All it requires is the power to order, before it is deleted, stored data. The remainder really illustrates the need to update existing surveillance and search and seizure laws. And this is still an issue even in Australia. So if I contrast my home state of Victoria, where the Crimes Act warrant in Victoria is the 100-year-old model of a search warrant, search, seize and carry away. You contrast that with a Commonwealth warrant which is specifically targeted at digital investigations. So what the Convention requires here is updating of your procedural laws, your substantive laws, to effectively investigate digital crime. It requires an expansive notion of jurisdiction to avoid safe havens, so for example, applying it to nationals when they are abroad. It underpins this with the mutual assistance and extradition provisions. It can be utilised as a mutual assistance treaty if necessary with other member states. So that could be useful if an agreement is not in place. But if an agreement is in place, that takes precedence. It provides for a 24/7 network, drawing upon existing 24/7 networks. The idea is cooperation to the greatest extent possible. But this is where it gets controversial. This is where it gets criticised. We're potentially cooperating to the greatest extent possible with a vast array of countries. And so the criticism that's often made is it's not sufficiently protective of rights. And I really like this incredibly pressing quote from Justice Brandeis back in 1928 in the US Supreme Court dealing with early wiretap case, saying that someday, without removing papers from secret drawers, it will be possible to reproduce them in court and expose a jury to the most intimate occurrences of the home. We are, of course, in that place. Some of our most intimate thoughts are not in secret drawers. We communicate them. They're not just outside the home, they're outside our country. They are routinely transmitted, particularly through the United States, because of its central role in modern communications. And so as we've seen with the revelations about PRISM, the community has become very much aware of just how much data is out there and how easily accessible it potentially is. Privacy has become very much the hot issue of the moment in this area. And those who oppose the Convention, particularly from a privacy perspective, criticise it because it does not include specific privacy protections. And personally, it seems to me that that was the pragmatic view. The idea that in an area like privacy, where even European and US views on privacy are very, very different, the idea that you could get international agreement on appropriate privacy protections, it would probably be doomed to fail. So the Convention adopts the pragmatic view. It hands the responsibility to the parties. It requires parties to comply and provide adequate protection of human rights and liberties according to applicable international instruments such as the ICCPR, include the principle of proportionality, put in place requirements, appropriate oversight, grounds of application, etc., and considering the interests of third parties. That is our responsibility. That is every nation that signs up responsibility. They determine adequate protection of human rights. The US, for example, I use the example again, would take a different view to us. We have Commonwealth power to demand an encryption key be handed over even if it is incriminating. That would not be permissible under the Fifth Amendment. We take different views even though we are very similar jurisdictions. I want to touch upon two examples which illustrate this that are very current, controversial topics. One we've seen recently with the revelations in Senate estimates, which was widely reported about, access to metadata, requests that can be made by AFP and other agencies for access to metadata without warrant. And that comes about under Chapter 4 of the TIA Act. And it allows an authorisation to be given to access existing or prospective telecommunications data, not content, without warrant. The authorised officer, it must be reasonably necessary for the purpose of law enforcement, and the officer must have regard to whether the interference with privacy is justifiable. Many people were surprised to see that on the last figures, at least that I had available, 2011-2012, there were over 300,000 requests for existing data and nearly 6,000 requests for prospective data. What was widely reported is the number of agencies that can gain access to existing data. I think it was a Victorian local council, actually, which was the only local council that had actually requested metadata, but includes agencies like the RSPCA, etc. Worth noting, I can't go into detail, but this is a very good example of how protections in legislation in this area tend to vary according to whether it is traffic data, that is IP addresses, call duration, etc., versus content, whether it is protection, for example. It's only criminal law enforcement agencies, and it only relates to serious offences. The part that comes out of the convention is that this material can be disclosed to foreign law enforcement agency. Now, this does flow from our accession to the convention. Previously, this would have been done through mutual assistance, but now we move to an agency-to-agency disclosure regime where it is appropriate in the circumstances is the test, except where it is prospective, and that still requires the permission of the Attorney General in order to have prospective surveillance of telecommunications data. There's a bit of detail there, but what I want to pick out of that is one of the things that I think is surprising in this area is that telecommunications data is not defined. It is taken to mean certain things, but it is not defined. And in this area, there can be a blurring. Is a URL, for example, metadata, or is it content? Certainly the statement is that a URL is not covered by this if it reveals content. It seems to me a very blurred area, and it seems surprising that telecommunications data is not defined there. Without commenting on the particular regime that's put in place there, the thing I want to emphasise is the convention does not require it requires us to be able to hand over information, but the protections we put in place is our decision. That is under our law, that is our idea of adequate protection. The convention does not require us to have specific protections in place. Very controversial issue is transborder searches. The nature of modern communications is such that law enforcement can very easily, deliberately or inadvertently engage in the collection of data in another jurisdiction without the knowledge of that foreign jurisdiction. This could be a deliberate covert search, or even something as simple as opening a Gmail account is effectively accessing data, most likely in the United States. And so this raises concerns about national sovereignty and enforcement jurisdiction. It is a general principle that law enforcement of one jurisdiction will not conduct operations in another without lawful authority. This was widely debated at the time the convention was drafted. Very, very controversial, very hard to reach agreement on, particularly because they didn't have much knowledge about it at the time. This capacity was not as advanced at the time. Article 32 deals with that. They carved out two specific exceptions. If the data is publicly accessible, then law enforcement can access it like everybody else. If they have the lawful and voluntary consent of the person with lawful authority to hand it over, that is also permissible. That in itself raises some issues about whether third-party providers who, under the terms of service, may have authority to release information, whether that constitutes consent, whether law enforcement agencies should be approaching third-party providers in other jurisdictions for data. It's a very controversial issue. A Council of Europe survey recently of member states revealed that many states are engaging in transborder searches of various types and take very different views as to what is permissible. Swiss law, for example, makes it a specific offence for a foreign law enforcement agent to conduct activities within its jurisdiction. It is an offence under the Swiss Criminal Code. Ivanov and Gorshkov is often talked about in this context. What that was, it was an infamous case in the United States. It was an FBI operation where two Russian hackers were lured to the United States, and under the pretext that they were being hired, they demonstrated their skills on laptops. They'd obviously just got off the flight and were very tired because they didn't think about the fact that they were using, or they didn't obviously know they were agents, but they used the laptops that were offered to them, which had keyloggers on them, and recorded all of the data. And included in that data was passwords to access data on the defendants' websites or servers in Russia. And the FBI went immediately to access that data without notifying Russian authorities. This was extremely controversial at the time in terms of agents carrying out a covert investigation effectively in another country. The point I want to emphasise is the Convention does not say anything about that type. That is still an open issue. It is neither authorised nor precluded. We have our own Section 3L of the Crimes Act, which allows an officer operating electronic data to access data, including data not held at the premises. Now, at the time this was drafted, and there's an equivalent provision in the Convention which talks about this, it makes sense. If you have, for example, local area networks, a local set of computers, and you're accessing one, you don't need to get another warrant to access a connected computer. But it raises for us the issue of, does it permit an extraterritorial search? And even if it does, what effect does that have on the foreign jurisdiction? The fact that it is lawful in this country does not necessarily make it lawful in another country. This issue is currently being debated at the Council of Europe level with a view to drafting an additional protocol. It's a live issue, it is going on, it needs to be addressed and clarified. It's now been years that we've talked about this as being unresolved. And just winding down to the last part of this, the Convention is often criticised in terms of it's not representative. It is, of course, a regional instrument. It can't change that. It came out of the Council of Europe. But it was always intended to have non-member state parties. How representative is it? Well, 45 of the 47 member states have signed, notably Russia has not signed. 35 member states have ratified, including the United Kingdom. There are 2 non-member signatories, Canada and South Africa. 4 non-member ratifications, including us and the United States, Dominican Republic and Japan. And significantly, the Council of Europe is engaged in a lot of outreach in terms of inviting countries to sign. And you can see it's a much more diverse range. Because the criticism of the Convention is it's the product of the developed world. And that was probably a large reason for its success. You have a relatively homogenous group drafting it, but that doesn't necessarily undermine the merits of its provisions. Could we have a UN convention? This seems unlikely in the immediate future. It was raised at the 2010 Crime Congress, and the member states could not agree on whether it should be suggested that the Budapest Convention be ratified. There is a clear split between those countries that support the Budapest Convention and those that see an international convention as the way forward. The UN focus, and this is really important, the focus now, which I think is really leading to some change, is on capacity building and technical assistance. And also the Cybercrime, the Intergovernmental Expert Working Group, which provided the study to have a greater understanding of what we're talking about. The 2013 Crime Commission essentially reached the same conclusions. Now I'm going to go through a series of slides now very, very quickly, and that's for effect. We talk a lot about the Budapest Convention, we talk about International Convention. What may be surprising to many is just how many regional instruments are operating now, and this has been the real shift in the last few years. Countries are aware of cybercrime, they want to develop cybercrime laws, but they want to bring their own regional perspectives. So if we look at back in 2001, the Commonwealth of Independent States, that's former Soviet republics. We have the Commonwealth, as in the Commonwealth of Nations, had its model laws on computer crime and electronic evidence back in 2002. The Harari scheme, which deals with mutual assistance, updated in 2011. Shanghai Cooperation Organisation, which includes China and Russia. The League of Arab States has its convention on combating information technology. The Caribbean, working with the ITU, has model legislative texts on cybercrime. The Pacific, model laws on cybercrime. Africa, an extraordinary amount of work going on in a very important continent, both in terms of population, numbers of countries, and in terms of particularly developing nations. So what we see is potentially a level of fragmentation. It's an incredibly dynamic environment, and I think whenever we're working with other countries, we need to be aware of a lot of what's going on that we may not be necessarily aware of. They're doing a lot of their own work, they look at other countries' models, they look at legislation that's in place. And as you see there from that UNODC diagram, and that's just looking at the binding or potentially binding conventions, you end up with this level of fragmentation. Even with the number of signatories at the moment, the Budapest Convention represents about 20% of the world's countries. I mean, that's still significant, but it's about 20% of the world. It's about 190 countries in the world. And so the process of acceding to that convention, with an international convention probably a long way off, that's going to be a slow process, and we can't afford to keep waiting. There are countries that wish to accede, there are countries that use the convention as a model and draw upon other instruments. The important point is to keep the focus on harmonisation. What we don't want is fragmentation. We need to ensure the interoperability. And the Budapest Convention is vital because of the number of countries that are already party and the model that it provides. And I think this is a really good illustration, the warning against the perfect being the enemy of the good. The idea that we would even have an international agreement that would suddenly deal with everything and we'd get is unlikely. We're actually probably in a way where we should be. We have a very good model in the Budapest Convention, and for those countries that accede to it, it's a very important and significant instrument. Other countries may not be able to or do not wish to, but we have this combination, as you can see in the quote there, of binding, non-binding, international and regional instruments. There is great potential at the moment. I come back to the point about capacity building being on the agenda. You've got the Council of Europe, the UNODC working with the ITU, regional initiatives, countries working with one another to build capacity. Because if we don't deal with capacity in those countries, they will be the source for crime that is directed against us. It is in all of our interests to work together. And a couple of things I just finish on noting just at a broad level. It always needs to be said in this context, and the Assistant Commissioner made the point clear, the number of truly high-level investigations is always going to be relatively limited. This is incredibly resource-intensive, dealing with very serious crimes. We need education programs, we need technical solutions, working with industry. We need to deal with so much at that level to deal with cybercrime because it can't necessarily all be prosecuted. But the interconnectivity that presents the challenge at the heart of cybercrime, that effortlessly networked world, also provides us with an extraordinary capacity to learn from one another. This is a crime type that you can see coming. If a scam is tried out in another country, it can be tried here. If there's an attack or a virus or whatever it might be on another country, it can be tried here. And we have the capacity, the ability, relatively easily, to learn from one another, whether that be operationally or legally. How did you deal with that? What approach did you take? How would we translate that to our environment? It's an extraordinary opportunity in the face of what is a very great challenge. And I'll leave it at that point. Thank you.